Hi, I'm Sibyl Winchester, Counsel for B&B Title Operations. This is Legal in 60 Seconds, where I break down real estate legal questions and hot topics in under a minute. Let's talk about something that often surprises agents in a transaction: FIRPTA. FIRPTA stands for the Foreign Investment in Real Property Tax Act. It's an IRS law that requires a buyer to withhold a portion of the sales proceeds if the seller is a foreign person. Here's the key point: if the seller is not a U.S. citizen or resident alien, the buyer may have to withhold up to 15% of the sales price and send it to the IRS. This isn't a title company rule, it's federal law. As a title company, we don't decide who is foreign and we don't give tax advice, but we do have to ask the seller to complete a certification so everyone knows whether FIRPTA applies. If the seller qualifies as a U.S. person, no withholding is required. If not, the withholding has to be handled before we can close. This is why it matters for you as realtors. You don't want your seller to be blindsided by a 15% holdback at closing. So it is smart to ask upfront whether your seller is a U.S. citizen or resident alien, so the issue is identified early. If FIRPTA does apply, the seller may want to talk to a CPA or tax attorney about possible exemptions or reduced withholding. Our role as a title company is to collect the right certifications, hold or disperse funds as required, and make sure that the transaction complies with FIRPTA. Your role as a realtor is simply to flag the issue early on so no one gets surprised at the closing table. Here's the takeaway: if your seller isn't a U.S. citizen or permanent resident, let us know right away so we can walk you through the FIRPTA steps and keep the closing on track. There you have it. Let us know what you like answered next.